Senator Carter for the floor.
Thank you, Mr. President, members. We've heard a lot about the Constitution throughout the course of this special session. Let me read to you the Eighth Amendment of the United States Constitution. It provides, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted, nor cruel and unusual punishment inflicted. That's our Constitution. Many years ago in 1972, in Furman versus Georgia, the United States Supreme Court considered it is assumed that in our decisions, speaking of prior decisions of the Supreme Court, that punishment by death is not cruel unless the manner of execution can be said to be inhumane and barbarous. And that is what we're discussing today. Whether or not the manner of execution can be said to be inhumane or barbarous. But the Supreme Court also continues and says, it is also said in our opinions that the prescription of cruel and unusual punishments is not fastened to the obsolete, but may acquire meaning as public opinion becomes enlightened by human justice. And here's how the Supreme Court finishes. It would seem to be incontestable that the death penalty inflicted on one defendant is unusual if it discriminates against him by reason of his race, religion, wealth, social position, or class. It would be unusual and cruel to subject one defendant to the death penalty in a disproportionately discriminatory manner. And way back when, in 1972, the United States Supreme Court found evidence that the death penalty was disproportionately assigned to those who were African American, those who were poor, those who were of other minority groups. The Supreme Court found it a racist practice. It was discriminatory. It was deemed unconstitutional. Not just whether or not the method the state goes about carrying out an execution, but the manner by which it is imposed. Since then, that's 1972, many states have enacted laws to figure out what's a humane way to try to carry out the death penalty. They're yet to find one. And many of them had tried to enact practices that try to address the discriminatory effect that the death penalty is imposed. Louisiana, that's not part of the call. We can't address that. And if you look at the current numbers that we have on death row here in Louisiana, it shows evidence that is being assessed in a discriminatory manner. We know because we just left the redistricting session that African Americans make up a third of the state, but yet we represent 2/3 of those who are on death row. Do you know the number? There's way too many homicides in my city, my parish, the parishes I represent in the great state of Louisiana, in our nation. There's a small amount of people on death row. How do they determine who is it that serves on death row and who is it that just gets to live out their life in jail? You know what's the number one indicator? The number one statistic? The race of the accused and the race of the victim. If it's an African American accused of killing a white person, that person is exceptionally more likely to get the death penalty. That is unconstitutional. That is cruel. That is unusual. I urge you all to vote against this. This is a bad bill. This is unconstitutional. And if you can't vote against it, I urge the federal courts, if you're listening, Strike this law down. Thank you.
Thank you, Senator Carter.